Good morning. Oh. Good morning. I'm Leah Tate, and I'm calling the second day of the Board of Psychology meeting in Los Angeles to order. It is 9:31 a.m. Ms. McCochran, can you please call the roll?
Kasuga, Cervantes, Fu, Harbsheets, Nystrom, Phillips, Riscate, Rogers, Tate.
Here. Thank you. And quorum has been established. We're going to do agenda item number 19, which the board will meet in closed session pursuant to Government Code Section 11126A1 to conduct the annual performance evaluation and consider the salary of the executive officer. So at this time, all board members will stay in the room and everyone else will exit. We will also be going in to closed session. Do I need to announce that as well? Closed session after the closed session? So after that closed session, we'll be going into another closed session, and we'll be meeting pursuant to Government Code Section 11126C3 to discuss disciplinary matters, including petitions for reinstatement, modification or early termination, proposed decisions, petitions for reconsideration, and remands. So thank you. I would love to have Ms. McCochran talk about CPD. Go ahead.
So attending today's board meeting provides you with CPD credit under Category 1, attendance at a California Board of Psychology meeting. For your CPD records, please notate today's date as November 3rd, 2023, and note that we are here for the board meeting. At the end of the meeting, I will announce how many CPD credits are awarded, and to receive meeting attendance credit, physical presence at the meeting is required. And just a note, in 2024, board meetings will be held in person, so physical attendance will be required, and committee meetings will be held via WebEx. Thank you.
Thank you, Ms. McCochran, and please let the record reflect that Dr. Phillips is currently in attendance. And for an estimate on how long we will be in the double closed session, I'm really just guessing an hour to 2 hours, perhaps. So thank you, and we will see you hopefully soon. Ooh, hello, thank you for returning. It's 12:54. Ms. McCochran, can you please call the roll?
Kasuga, Fu, Harbsheets, Phillips, Riscate, Rogers, Tate.
Here.
Quorum established.
Thank you very much. 2 housekeeping items. The first one is that it is 12:54 and we are going to push to 2 o'clock and then adjourn due to airlines. All of us have traveled. So I wanted to let everyone know that. And the second item is that the board voted in closed session to approve a 1.5% salary increase for the executive director, Ms. Antoinette Sorik. We're going to start with agenda item number 21. This is public comment on items not on the agenda. The board may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. I ask individuals making comments to not discuss the specifics, including names, as to pending complaints, pending licensing applications, or pending disciplinary matters. While there may be a desire to engage in further discussion, the board cannot at this time. Although this may give the impression we are not being responsive, these procedures are critical to ensure the compliance with the Open Meetings Act and to avoid compromising the speaker's goals or the board's mission. Each speaker will have 2 minutes, and if you have a comment, please come forward, take a seat, and raise your hand. Thank you. Coming back to the board, we're going to jump to item 24, and this is the, come forward, have a seat, raise your hand.
I heard you say we have 2 minutes, and I actually have a statement that's about 4 minutes. I don't know if you can accommodate that. I haven't been here in about 4 years, so making up for lost time.
Go ahead, you have
All
4
right.
minutes.
Thank you. Good morning, Madam President and members of the board. I'm Kathleen Russell, as many of you know, the Executive Director of the Center for Judicial Excellence. It's been a long time. It's very nice to be back in person with all of you. I'm here, first of all, to personally thank you for your support on Senate Bill 331, or Peaky's Law, which you may know was just signed by the governor into law. This bill is an important step in the right direction that will protect our state's children from the harmful threat therapy that they've been forced to endure many times at the hands of your licensees. I know it was not an easy position for this board to take, given some opposition that arose, but it was valuable and much appreciated by the survivors of these traumatizing programs and by our organization. You may wonder where we've been the past few years. We co-led the effort to pass Caden's Law through Congress with Representative Brian Fitzpatrick, which was signed as part of VAWA by President Biden in a White House ceremony I was pleased to attend last year. This federal law creates financial incentives for legislatures to modernize their child custody laws, and it encourages states to restrict the use of unproven threat therapy programs like Peaky's Law does. I do hope and trust that your support for Peaky's Law will also translate into more meaningful discipline of your licensees who engage in this soon-to-be illegal activity in our state. Therapy is meant to heal childhood trauma, not create it. Thanks for being on the right side of history for this. Next, I want to revisit the final action item approved by the board from our 2018 stakeholder meeting. You agreed to introduce a bill to close the loophole that allows your licensees to withhold crucial case files from the board, thereby thwarting investigations into their misconduct. Now's the time to meet with legislators to secure a sponsor for next year's bills, and we hope you're working hard to find one. We'd be happy to ask Senator Rubio if she might carry it, since we were together in DC last week. We discussed the dangers of these newly banned programs in a high-level meeting at the U.S. Department of Justice after the senator spoke at our congressional briefing. Please let us know if we can help. Lastly, I'm here to share some grave concerns about a disciplinary decision the board made, apparently an error, and I won't be naming the licensee. I'm providing materials to each of you to please consider, since a pioneering international leader in the field of trauma has been harmed in a way that doesn't mesh with the board's recent progress in increasing public protection, especially for vulnerable children. I encourage you to reflect upon the need for consistency in your disciplinary decisions. The board's own longtime trainer and expert, Dr. Roeder, found no unethical behavior by the licensee in question. A board expert unfamiliar with the ethics codes for emergency risk assessments was heavily relied upon by the board and the ALJ in this case, and crucial errors were seemingly made. Tremendous concern has arisen from more than 100 organizations, psychologists, law and psychology professors, and others from as far away as New Zealand and the Balkans, that the board's decision in this case is creating a chilling effect that will dissuade California psychologists from conducting emergency risk assessments for suicidal youth. Please review the materials and ask yourselves if this decision was in fact mistaken. If it was, then I urge you to please withdraw and rescind your accusation against a board-certified clinical neuropsychologist and board-certified couple and family psychologist with no disciplinary history and more than 45 years of experience in an illustrious career as a pioneering expert in childhood trauma. Thank you for your continued work to protect the public from misconduct. And I have these for each of you.
Hello. Thank you for your comments and for making copies for everyone. Any other public comment? And I'm sorry I didn't see you sitting over there earlier. Okay, making sure I'm not missing anyone. Okay, thank you. We're moving on to agenda item number 24. This is the election of officers, and Mr. Payne is going to take the lead.
Thank you. We're good. Scoot in a little bit more. Thank you. Per board policy, the way we will do this is first, I will take nominations, and then I will ask the nominee if they accept that nomination, and the nominations are for vice president and president. Yes, so I'll do vice president first. And so, are there any nominations for vice president? I will go down the line alphabetically. Member Kasuga, do you have any nominations for vice president?
I would like to nominate Dr. Shakunda Rogers, Vice President.
Dr. Rogers, do you accept the nomination?
Yes, I accept the nomination. Thank you, Dr. Kasuga.
Member Fu, do you have any nominations for vice president?
The person I was going to nominate has been nominated.
Very good.
Dr. Rogers.
Dr. Harb Sheets, do you have any nominations? Dr. Phillips, do you have any nominations? Member Riscate?
Keeping this.
Very good. Vice President Rogers, do you have any nominations?
No nomination.
Okay. And President Tate?
No additional
Very
nominations.
good. Then with there being a single nominee and that nominee having been accepted, all those in favor may raise their hand with an aye. It's unanimous. Thank you very much. Congratulations. And now we'll move to president. And now for president, Member Kasuga, do you have any nominations?
I've been fortunate to be the first one on this microphone, and with that, I would like to nominate Dr. Tate for president.
Okay, very good. And Dr. Tate, do you accept the nomination?
Yes, I do.
Very good. Member Fu, do you have any nominations?
No additional nominations, thank you.
Good. Dr. Harb Sheets, do you have any nominations?
No additional nominations.
Dr. Phillips?
Thunder has been stolen, no additional nominations.
Good. Member Riscate? Vice President Rogers?
No nominations.
And President Tate?
I have, no, I don't.
Very good.
Thank you.
Having there been one nomination and that nominee has accepted the nomination, can I get a vote for all those in favor of President Tate as the nominee? And that is also unanimous. Congratulations, President Tate.
We're going to jump back to agenda item number 22, which is the legislative, yes.
We're starting January 1st, 2024, correct?
That is correct.
Okay.
Thank you for the clarification. Agenda item number 22 is the legislative and regulatory affairs update, and Mr. Polk is coming up. This is agenda item 22.
Good afternoon. Starting with the legislative update, just information that all the agenda items for the legislative and the regulatory update are informational and there's no action required. Beginning with agenda item A1, this refers to Senate Bill 816. 816 amends the Business and Professions Code of 2987 by increasing the board's fees related to the applications, initial licensure, registration, and renewals. On September 21st, the bill was presented to the governor. On September 22nd, the board submitted a request for signature letter that was submitted to the governor's office, and on October 10th, Senate Bill 816 was signed and approved by the governor. Board staff is currently working on implementation of Senate Bill 816. Yesterday, there was an advisory that was sent out advising stakeholders of the fee changes, and the advisory has been posted to the board's legislative page on the website. At that time, this includes my report on item 22A1 for SB 816, and I'm open for questions.
Any board members have comments or questions for Mr. Pope regarding SB 816? Go ahead.
I understand the advisory went out yesterday, and the advisory included a link to the page. But would this be a good time, perhaps, to share a little bit more about why the bill was introduced and what the fee increase would look like, and also a look ahead to perhaps a discussion in what February might look like, Ms. Orrick?
As always, thank you for the tee up, Mr. Fu. Yes, I would say over the last, it's been several years, the board had been operating in a structural deficit, and we were working closely with the Department of Consumer Affairs, monitoring our budget and what we had going into our surplus, which we are mandated to put money in our surplus for a rainy day fund. That process was a process where we engaged with stakeholders. We had a couple of stakeholder meetings where we talked about what made sense formula-wise to spread the fees in such a way that would maintain board operations and continue us to be running in the black and not the red in future budget years. Part of that was, it's a three-pronged effort. The first was ensuring that our fees were increased to their statutory cap, which we did through regulation, and that was effective July 1, 2022. And then once that was done, that kind of prolonged the target date for when we would not be reverting any funds into the surplus. So that necessitated a legislative change, which over the past year we've been working with the Senate Business and Professions Committee to ensure the fiscal viability of the board. That bill, SB 816, was signed by the governor and is effective January 1, 2024. The next step will be to look at the regulatory process to see if there's a way in which we can increase the fees to allow for room for increased customer service through added staff and structural support. That's the next step of the phase. In February, we will be having the budget office give an overview of the history of the fee increase, how we got to this point, what are the triggers for fee increases in the system, and then we will look at next steps at additional outreach opportunities. That's kind of a preview of where we were, how we got here, as far as being in a structural imbalance, spending more than we're bringing in, and we had not, in statute, raised our fees in 30 years. That's something that I think the legislature looked at in a positive way, because we've been very fiscally responsible with our discretionary funds. Part of running a regulatory entity is there are discretionary funds and non-discretionary funds. Non-discretionary funds are things that are not within the board's control that we are required to pay out. Things like employee salary, benefits, our attorney general fees, Division of Investigation fees. Discretionary funds are things such as office supplies, equipment, whether we travel for board meetings, and such. So we've been monitoring our discretionary funds. We haven't traveled in 3 years, for example. That was something that we looked at even prior to COVID. What are ways in which we can save money? So those are things that we did before our fee increase. So does that help answer?
And Ms. Sorek, just a couple questions. So with regard to the fee increase, there hasn't been a fee increase in 30 years, is that correct?
There hasn't been a statutory fee increase. As I mentioned, we did, as a step one to the budget process, to help with our structural imbalance, we increased our regulatory fees to their statutory cap. So for example, we went from $400 to $500 for a license renewal. So that was something that we did in regulation. So for licensees out there, there may be an impression that you have increased fees. Yes, we did in our regulation, but we had not increased in statute through legislation in 30 years.
And when you talk about the structural imbalance, and I know we'll talk more in February, the structural imbalance was a result of increasing costs in our non-discretionary outside of the board's control. Is that correct?
Correct.
So we essentially had a healthy surplus that we were relying on to cover increasing costs that we were not essentially made up for.
Right. So that's a good question. We were using the bottom line remaining monies that we were collecting to cover increase in costs over time. So that was going to catch up with us at some point, which it did. And then the bottom line wasn't able to cover those things. So for example, we were offering the CAPLE or the Law and Ethics exam 4 times a year, and we were not paying for those versions. So our first, regulatory fix was to make sure we were recouping the cost for the administration of that exam.
And one final question, which is, this change also includes some reduction in fees, is that correct?
There are a couple of reductions, yes. But by and large, there are more increases than, yes, reduction.
Understood. All right, thank you.
Any other board comments or questions for Mr. Polk? I'd like to open this item up for public comment. If you have a comment or question on 22A1 SB 816, please step forward and have a seat and raise your hand. Okay, Mr. Polk, we can move on to A2.
Agenda item A2 is reference to Senate Bill 887. SB 887 streamlines the application process by allowing verification of completed coursework, specifically in suicide risk and assessment and aging long-term care, by a review of the transcript that clearly indicates the course title of those specific courseworks has been completed. Additionally, SB 887 allows the department chair to act as an additional entity to provide written certification. In doing so, provides convenience for applicants in the case that the course titles on the transcript does not clearly indicate the coursework that was completed. On September 20th, SB 887 was presented to the governor, and at that time, a request for signature letter was also submitted to the governor's office. On October 8th, SB 887 was approved and signed by the governor, and board staff is currently working on the implementation plan for the requirements of SB 887. And that includes my report on item 22A2, SB 887. I'm open for questions.
Any board comment for Mr. Polk?
I just wanted to make a comment that this is one of those things that I believe we discussed on our legislative visits, and it's good to see it pushed through.
Raise your hand.
Oh, it bears saying that this does make the licensure process a little easier, a little simpler, quicker to process licensing applications.
Thank you. Any other board comment? I'd like to open this item up for public comment. This is SB 887, agenda item 22A2. If you have comments, please come forward and have a seat. Okay, Mr. Polk, item 22B.
Starting off with item 22B1, this is in reference to Assembly Bill 282. Assembly Bill 282 revises Section 2914 of the Business and Professions Code by adding language to allow applicants to be eligible to take the required licensure exams that include the examination for professional practice in psychology, also known as the EPPP, and the California Psychology Law and Ethics Examination, commonly referred to as the CAPLE. Allows them to take the licensure exams at any time after all academic coursework required for a qualifying doctoral degree is completed. In addition, AB 282 requires the board to remove the requirements of completing the qualified supervised professional experience hours that were previously required to be eligible to take the EPPP and the CAPLE, and that's currently outlined in regulations 1388 and 1388C. Lastly, AB 282 requires the board to implement a process to verify any additional eligibility requirements implemented by a national licensing exam entity, such as ASPBB, and referring to the exam of EPPP Part 2 once it is required. At the August board meeting, the board adopted a support position on AB 282 based on the amendments that were added at that time. September 13th, AB 282 was presented to the governor, which was signed. I'm sorry, let me back up. So September 13th, the AB 282 was presented to the governor. September 20th, the board submitted a request for a signature letter to the governor's office, and AB 282 was signed and approved by the governor on October 7th. AB 282 does require the board to complete a regulations package. However, the board has already drafted and approved language to include the requirements of Assembly Bill 282. And at that time, this includes my report on item 22B1.
Thank you. Is there board comment regarding AB 282? I'd like to open it up for public comment regarding AB 282. If you have a comment, please come forward and have a seat.
Hi, it's Elizabeth Winkleman, Dr. Elizabeth Winkleman with the California Psychological Association. I just wanted to thank the board again for their support for this bill, which was co-sponsored by CPA to help streamline the licensure process. And for just to clarify for those, for myself and for the people who are watching, in terms of the date, the anticipated date that the regulations would be implemented and that people would be able to start taking the licensing exams in this more streamlined fashion as prescribed by the bill. So is there an anticipated date?
Yes, there is. Ms. Sork might have the actual date on there. No? Okay. Give me 1 second. I gotta look up the implementation plan. Oh, Steph, Ms. Chung? Sorry.
Thank you, Dr. Winkleman, for your questions. So for this, we plan to, because the language has already approved, which is great, so we're like one big step ahead already. And then so we will be working with the, of course, the department, get through the whole regulatory package process. And we are hopeful that by the Q4 in 2025 that it would be approved. So we are shooting for that goal, and then just in time for implementation for the new structure in 2026 January. So that is our plan and goal, to shoot for that effective implementation date.
Okay, great. Thanks so much.
Thank you. Mr. Fu, did you have a comment?
This is a question for Ms. Chung. Ms. Chung, someone might hear that timeline as being particularly lengthy. And one of the things that might be helpful to understand is, I think, and you mentioned this earlier, is that the board already has done everything up to the point of getting this package ready, and the 2-year or 18-month to 24-month period that you just described, that is a process that the board does not control. Is that correct?
That's correct. So the board was already contributed to this part is by reviewing and approving the language. So that is always like the starting point of creating or promulgation of regulations. And then once the board passed that point, it will be delegated to staff to work on the remaining process, which is a long process as we kind of understand that process to work with staff, our legal staff on curating that package, getting it ready for the Office of Administrative Law to review and approve, and then go through the whole process of public comment period and all of that. So it is a lengthy process, and typical regulatory package would take 2 to 3 years. So that would be like a normal timeline for us regarding working on regulation package.
Perfect. Thank you. Appreciate that clarification.
Thanks. Any other public comment? Okay, thank you. Mr. Polk?
Moving on to agenda item 22B2. Thanks. This is regards to Assembly Bill 665, which changes the law to allow a minor 12 years of age or older to consent to mental health treatment or counseling on an outpatient basis or to a residential shelter services. If the minor is found to be mature enough to participate intelligently and without having to present a danger of serious physical or mental harm to themselves or others, or if the minor is the alleged victim of incest or child abuse. At the August board meeting, when AB 665 was presented to the full board, the board adopted a support position on AB 665. On September 11th, the bill was presented to the governor, and a request letter requesting the governor sign AB 665 was submitted on September 20th. On October 7th, AB 665 was then approved and signed by the governor. And that includes my report on AB 665.
Thank you. Oh, go ahead.
So this is an interesting bill because there have previously been bills that allowed, or statutory authorization to allow people 12 years or older to consent to services, but there were certain other conditions that had to be met in order for that consent to be given. Here, they've just whittled it down to being able to participate intelligently enough in the services to be able to consent, which is a much easier process, and it certainly simplifies what our licensees need to know in order to obtain consent from somebody in that.
Much cleaner overall, I think, a cleaner wording. Any other board comment? I'd like to open up this item for public comment. If you have a public comment, please come forward and have a seat. Okay, back to you, Mr. Polk.
Next up is agenda item 22B3. This is in reference to Assembly Bill 883, which requires licensing boards under the Department of Consumer Affairs to expedite applications for applicants that provide evidence that they are currently enrolled in the U.S. Department of Defense's SkillBridge program. The SkillBridge program allows service members to gain specific training, apprenticeships, or internships during the last 180 days of their service. When AB 883 was first presented to the board adopted a support position on AB 883, and that position continued out through the legislative session. AB 883 was presented to the governor on September 14th, and the board and a request for signature letter was submitted to the governor's office as well. On October 7th, AB 883 was approved and signed by the governor, and that includes my report on AB 883.
Thank you. Any board comment for Mr. Polk on AB 883? Any public comment for AB 883? Please come forward. Okay, back to you.
Moving on to agenda item 22B4. This is in reference to Assembly Bill 331. Assembly Bill 331 prohibits the court from ordering family reunification treatment programs or services, including but not limited to camps, workshops, therapeutic vacations, or educational programs. Additionally, SB 331 requires the Judicial Council to establish judicial training programs for individuals, including judicial officers and referees, who perform duties in domestic violence or child custody matters. The training topics included child sexual abuse, physical abuse, emotional abuse, and that's just to name a few of the courses. SB 331 requires the Judicial Council to submit an annual report to these training programs starting on or before January 1st of 2025 to the legislator and relevant policy committees that include the titles of the training courses being offered and the number of judicial officers that attended each trainings. When SB 331 was presented to the board at the August board meeting, the board adopted a support position on SB 331. On September 18th, the bill was presented to the governor, and a request for signature letter was also submitted to the governor's office on September 20th. On October 13th, the bill was then approved and signed by the governor. And that includes my report on SB 331.
Thank you. Any board comment on SB 331? Is there any public comment on SB 331? Please come forward.
Hi there, me again. Just wanted to mention that we are having a follow-up meeting with the US DOJ in the next week or two. And I know from speaking with one of you that there's interest in understanding both at the AG's office and this board how that will be implemented, particularly as it relates to reunification therapy programs and the ban on those. So we will keep you updated and in the loop as that rolls out. Thanks.
Thank you for your comments. Dr. Phillips?
Congratulate Ms. Russell on her tireless efforts to move this issue forward and to educate us as a board as to the importance of taking the appropriate steps. Thank you very much.
Is there any other public comment for this item? Okay, Mr. Polk.
Moving on to agenda item 22B5, AB 996. This bill would have required licensing boards under the Department of Consumer Affairs to develop and maintain a conflict of interest policy that would have discouraged the qualifications of any continuing education course if the provider of that course had an economic interest in a commercial product or enterprise directly promoted in the course. The board adopted an opposed position on AB 996 as it was felt that the bill would have limited the continuing education courses that were provided, and issues regarding the development of a conflict of interest policy was expressed. Numerous opposed position letters were submitted to the different Assembly and Senate committees as well as to the author's office. On August 17th, AB 996 was placed on the inactive file, and the bill has been determined a 2-year bill, and there was no further movement on AB 996. Board staff will continue to monitor this bill if it is presented or if it moves forward into the next legislative session, and that includes my report on 996.
Thank you. Board comment on AB 996? Is there public comment for AB 996? Please come forward. Thank you.
Moving on to agenda item 22B6. This is in reference to Senate Bill 372, which would require the board to update a licensee's or registrant's name and/or gender when the board receives specific government-issued documentation. Additionally, SB 372 requires the board to remove the licensee or registrant's former name and gender from the online verification or the online license verification system, and then now treat that information as confidential and remove enforcement records. But it would allow us to advise the public to contact the board directly to receive the enforcement information. In August, the board adopted a support position on SB 372 after the bill was amended to narrow the scope of who SB 372 would apply and the requirement to post language on the online verification system advising the public to contact the board directly to obtain the enforcement information. SB 372 was presented to the governor on September 11th, and on September 20th, a letter requesting the governor to sign SB 372 was submitted to his office. On September 23rd, the governor approved SB 372, and the board is currently working on implementation for the requirements of SB 372, and that includes my report on agenda item 22B6.
Thank you. Board comment for SB 372? Is there public comment for SB 372? Please come forward.
Hi, Dr. Elizabeth Winkleman again from CPA. I wanted to thank the board for their support of SB 372. It's another co-sponsored bill of CPAs, and I wanted to just ask in the meeting so that people who are watching are clear about what would they need to do if a person is in this situation. And once the bill is implemented in 2024, what kind of paperwork and how would they file a request to get the information with their previous name and gender and/or gender removed from the BREEZE the BREEZE public listing?
Thank you, Dr. Winkleman, for your question. I have heard the latest from the department is that there will be like a global implementation of this bill. So we are still waiting for more information on the processes. But once we know what the new process will be, we will be posting some information about that. So stay tuned. We don't have any new information to share at this time.
Very good. Okay, thank you. And Mr. Polk, thank you for sharing the information about how if somebody did have a question regarding any previous discipline, the public would still be protected because the information is available on request, that it just would not automatically be popping up on the license search. So thank you for clarifying that. That's the other question that we have heard from members about how would this be implemented in a fair way that's protecting the public, but it's also protecting people from discrimination and threats who have changed their name and or gender. So thanks very much.
Is there any other public comment on this item? Thank you. Go ahead.
Moving on to agenda item 22B7. This is in reference to Assembly Bill 544, the Bagley Clean Teleconferencing Act. This bill amends the existing law that will remain operative after July 1st of 2023, which would allow state bodies to hold public meetings through teleconferencing with specific notice and accessibility requirements. It also specifies that members of the public can address the state body without having to submit public comments prior to the meeting. Additionally, the bill provides access for people with disabilities and requires state bodies to disclose if any other individual 18 years or older are present at the remote location of the meeting. And SB 544 contains additional requirements and gives 4 different options to hold meetings. On August 18th, the board adopted a support if amended position. The amendments were regarding the removal of the provisions related to the disclosure of individuals of 18 years or older who are present and the requirement to adjourn the meeting due to technical issues. Position letters were submitted to the Assembly Committee on Appropriations, and an in-person testimony was provided at the bill hearings by staff. On September 18th, the bill was presented to the governor, and however, the proposed amendments were not accepted. On September 22nd, the bill was approved and signed by the governor. And That includes my report on SB 544.
Thank you. Board comment regarding SB 544? Is there public comment on SB 544? Please come forward. Okay, Mr. Polk, back to you.
Next up is agenda item 22B8. This is reference to SB 815. SB 815 transfers the registration, regulation, and enforcement of research cycle analysts from the medical board to the Board of Psychology effective January 1st of 2025. The bill would transfer funds collected from the licensing and regulation of research cycle analysts from the medical board to the Board of Psychology as well. On August 18th, the board adopted a support amended position on SB 815. The proposed amendment was to match the fees with the current law, as the bill at that time had the fees at a lower amount. On September 5th, the bill was amended to make the fees match the current law. On September 20th, a request for signature letter was submitted to the governor's office, and on September 30th, the bill was approved and signed by the governor. Currently, an implementation plan has been drafted by board staff, and the board staff will be meeting to discuss the implementation of SB 815 that will be effective January 1st of 2025. And that includes my report on SB 815.
Thank you. Is there board comment regarding SB 815? Mr. Fu?
For the implementation plan, Mr. Polk, when the board after staff has met about it and the board is briefed about it, could you answer the question about whether or not the board will be inheriting any staff from the medical board? So I don't need an answer today, just meaning that when we do get the briefing back on the implementation plan, we'll be curious if we get any staff from the medical board to the psychology board as a result of inheriting this this new registration category.
No.
Well, way to spoil the surprise, Dr. Phillips. I was anticipating something lengthier in 2024 or 25. Thank you for answering my question.
Mr. Fu and I will have an opportunity to look at this closer on the ad hoc committee for
The question has been asked
research psychoanalysis.
and answered. Any other public comment on SB 815? Please come forward. Okay, thank you. Back to Mr. Polk with no extra staff. Thank you.
No. Unfortunately. Next up is agenda item 22B9. This is regarding Senate Bill 815, which expands the criteria for a qualified autism special professional to include behavioral health professionals, psychology associates, marriage and family therapists, associate clinical social workers, or associate professional clinical counselors. This bill also expands the criteria for a qualified autism services paraprofessional to include a behavioral health paraprofessional. The Department of Developmental Services, known as DDS, are required to adopt regulations to address the use of behavioral health professionals and behavioral health paraprofessionals in behavioral intervention services. The bill requires the Department of Developmental Services to establish the educational or experience qualifications and professional supervision requirements necessary for these positions to provide behavioral intervention services other than applied behavioral analysis. On August 18th, the board adopted a support position on SB 805. On September 14th, the bill was enrolled and presented to the governor. And on September 20th, the board staff submitted a request for signature to the governor's office. On October 8th, the bill was approved and signed by the governor. And that includes my report on SB 805.
Thank you. Any board comment on SB 805? Is there any public comment for SB 805? Please come forward.
Dr. Andrea Davis. I am the president of the bill sponsor, the DIR Floor Time Coalition of California. We've worked for 6 years with Senator Portantino on this effort and 4 years before that. So you can imagine my sense of gratification on the 18th when the board decided to support our bill. That was a huge day for us and for me personally, and I just wanted to provide a formal thank you for considering the merits of this legislation, taking a support position, and offering staff time to work with us in the future on now working out the actual regulations with the Department of Developmental Services on the exact requirements for supervision, training, experience, and education of the behavioral health professionals and behavioral health paraprofessionals who will be providing group practice care for patients with autism. And this is revolutionary legislation. There's no other state that actually asks commercial insurances to cover other approaches to treatment. So it opens up and stops restricting the practice of psychologists. So we're very grateful to the board, and thank you very much for committing extra time on the staff to provide technical assistance in the future as we work out those regulations. Thank you.
Thank you for your comment and your feedback. We appreciate that. Mr. Polk, are you ready to move on to the watch bills?
Yes.
Have at it. Did I miss something? Oh.
Or a clarification, Madam President, would you like us to specifically call out any watch bills that you would like Mr. Polk to call out, or is the preference for us to hear all the watch bills?
We're not going to hear all the watch bills, but Mr. Polk is going to say, well, you already said it, but he can say it too. Just listen.
Agenda items 22C through 6 are the bills watch bills. There is no active positions on these bills. However, if the board members have any specific questions on any of the watch bills, I'll be more than happy to answer them.
Are there any board comment on the watch bills, Mr. Food?
Thank you.
Any board comment on any of the watch bills?
I just wanted to have a comment that I appreciate Mr. Polk for taking on watch bills that were recommended by board members, and one of them was AB 248. Thank you.
You're welcome.
Is there public comment on any of the watch bills? Please come forward and have a seat. Okay, we are moving on, and I think, Mr. Polk, you're off the hot seat. Maybe just for a brief minute, so don't move, though.
Okay.
Okay. We're moving on to Agenda 22D. This is legislative items for a future meeting. The board may discuss other items of legislation in sufficient detail to determine whether such items should be on a future board meeting agenda and/or whether to hold a special meeting of the board to discuss such items pursuant to Government Code Section 11125.4. So I'm going to open that up to the board.
Madam President, and I would like to request, if time permitting, sometime in the next 4 meetings next year,
Okay.
No special meeting needed, would be curious if the board can receive a briefing on the implications of the Mental Health Act changes to Prop 63, as well as the accompanying bond measure related to mental health facilities, and how that might impact our board and its mission, as well as any potential revenue that might come to the board as a result of that.
Good suggestion. Any other board suggestions, comments? Another one?
And not another one, and ever mindful of the trade-offs that we have to make when we ask for these additional briefings, which is if staff finds that there's not something substantive relative to the board's operations, that to just come back with we did analysis, no substantial item, and there's no need for the board to have a full briefing.
That's a good addition. I like that. Any other legislative items the board would like to see in the future? Opening this up for public comment. If anyone in the public has a legislative item they would like to see on the agenda, can you please come forward? Okay, thank you. Oh.
Dr. Tate, I just wanted to have like more of like a general kind of like things that we should probably looking at watch bills for are anything that's related to the future of the profession in terms of any kind of like drug-assisted therapies. If there are any legislation regarding that, I think that we should be, watching them, and anything related to advancements in technology when it comes to AI and therapy and our mental health or psychological services related to AI and augmented reality. I think that we should be always looking at the future of the field and what is the changes that are happening in the practice of psychology.
Thank you. Appreciate that. Did you get perfect? Okay, that was you. We did public comment. Great. We're now moving on to agenda item number 23, the regulatory update review and consideration of additional changes. Back to you.
The items listed under the regulatory update, they're informational items. There's no action required on those items at this time. Starting off with agenda item 23A, this is regards to the inactive psychological associates regulatory package. This package allows a psychological associate to request that the board place their active registration in an inactive status. In addition, the proposed regulations would allow the board to place the registration in inactive status when the registrant has no primary supervisor. While the registration is in inactive status, it will stop the time counting towards the cumulative total of 6 years of registration limitation. The board is also proposing the adoption of the process for reactivating and activating psychological associate registration. This package is in the production stage. This phase includes board-approved text and collaborative reviews by board staff, legal counsel, and budget staff to prepare the initial documents for submission to the director and agency. Just a little background: on August 18th, the proposed regulatory language was presented once again to the board for approval regarding the inactive timeframe, and the regulatory language was updated and accepted by the board members, and the regulatory package is continuing in the rulemaking process. And that includes my report on item 23A.
Thank you. Is there board comment on item 20? Is it 20? I have 23A. Great. 23A. I'd like to open it up for public comment on item 23A. If you have a comment, please come forward. We're moving on to 23B. Mr. Polk?
Item 23B is an update on the board's disciplinary guidelines and uniform standards related to substance abusing licensees regulatory package. This package updates the board's disciplinary guidelines, including conforming changes required by the passing of AB 2138. The board's new regulations regarding criminal convictions and substantial relations criteria, and the department's uniform standards for substance abusing licensees. This package is in the production phase. Once again, this phase includes board-approved text and collaborative reviews by board staff, legal counsel, and budget staff to prepare the initial documents for submission to the director and agency. On August 18th, the board voted to adopt the proposed regulatory language, and staff is, like I said, is preparing the initial submission documents for DCA and agency review before it begins its filing with the Office of Administrative Law. And that includes my report on the disciplinary guidelines for regulatory package.
Thank you. Is there board comment on item 23B? Is there public comment for item 23B? Please come forward and have a seat. Mr. Polk?
Moving on to item 23C. This is the Pathways to Licensure regulatory package. This package streamlines the licensing process and removes unnecessary barriers for applicants and the supervisors who are supporting their training. Right now, this regulatory package is in the drafting phase. This phase includes preparation of the regulatory package and has collaborative reviews by board staff and legal counsel. And that includes the report for 23C.
Is there board comment on 23C? Is there public comment for item 23C? Go ahead.
Okay. Moving on, item 23D. This package updates the board's enforcement provisions. Currently, this package is in the drafting phase, which is we are starting the preparation of the regulatory package and doing collaborative reviews by board staff and legal counsel. And that's the report for 23D.
Thank you. Any board comment for 23D? Is there public comment on item 23D? Please come forward. We are moving on to 23E, Mr. Polk.
23E, this is just an update for the regulatory package that would update the board requirement for professional corporations provisions. As the previous regulatory package, this one's in the drafting phase as well, so we're preparing the regulatory package and having reviews by board staff and legal counsel.
Thank you. Board comment on item 23E. Is there public comment for item 23E? 23F.
23F. This is the regulatory package, updates the statutory and regulatory sections needed to implement the EPPP Part 2. This regulatory package is in the drafting phase as well, so board staff is preparing the documentation and doing collaborative reviews with legal counsel.
Thank you. Any board comment on this item? Is there public comment for this item? Please come forward and have a seat. Okay.
You're welcome.
We're moving on to agenda item number 25, and this is recommendations for agenda items for future board meetings. The board may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. I'm opening up to the board members first. Any items for future board meetings? Mr. Fu.
This isn't an item per se, but just reflecting on the petition hearings, if it's possible to have the petition hearings be spaced out, one in the morning and one in the afternoon, because I think 90 minutes is ambitious for us to get through the petition hearings, and I think just given the fact that we will have licensees attending our petition hearings, and we'll have closed session as a result of that, it might be helpful in terms of time management to split that up.
That would be amazing in terms of time management, so I love that suggestion. Mr. Phillip?
The only consideration would be the time of the ALJ. They probably want to do all their everything together as much as possible so that they can get out. But there may be a way to do it where we do one before lunch, one after lunch, and then closed session. So there may be a way to manage it, but we should be cognizant of the ALJ's timer.
Yes, and I think 90 minutes seems like we're keeping our ALJs beyond the 3 hours we have them booked. Yesterday, I think we ran closer to 5 hours. So just being realistic that instead of we're looking at averages, let's go for the average rather than the optimal scenario.
And 90 minutes is not optimal. Or average, that's true. Any other board suggestions for future agenda items? Dr.
Dr. Tate, I just wanted to suggest that we continue to have our mindfulness on our next board meeting and strategic planning meeting.
Already on the docket, that's happening.
Thank you.
Perfect.
Twofer.
Yes. Any other suggestions from the board? Any public comment? Any suggestions for future things? Please come forward. Happy to entertain them.
Hi, I don't have a future agenda item. I'd just like clarification from the board about whether the packets I brought with me from Northern California will be delivered to the members. I haven't seen that happen, so.
Yes, I'm going to make sure that the board gets copies of the documents that you presented.
When will that happen?
I don't know. I don't know what is the typical turnaround time that we've done for
I mean, I thought they would be given today.
Well, legal counsel's going to obviously review them first to make sure they're appropriate documents in public and all of that. And once legal counsel's able to do that, then I can get copies to the board.
Okay, thank you.
Yeah.
Is there any other public comment regarding recommendations for agenda items? Mr. Fu?
Mr. Payne, for clarification, the concern is for that we would be violating government section code related to ex parte communications. Is that correct?
Member Fu, yes, there's ex parte communications. There's also privacy concerns and a few other things that are legal constraints that legal counsel will need to review first.
Okay, I do not see any public comment or board comment. Before I adjourn for the day, I'd like to give Ms. McCochran just a few minutes to explain about CPD credit.
So thank you for attending the board meeting. You will receive 6 CPD hours for your participation under CPD Category 1, attendance at a Board of Psychology meeting. For your records, please note today's date as November 3rd, 2023, the name of today's meeting, which is board meeting, and 6 CPD hours. To receive meeting attendance credit, physical presence at this meeting is required. Thank you.
Thank you, Ms. McCochran. And with that, thank you to the board members and to the public for attending our meeting. And hopefully we will see you at Strat Plan in December or otherwise at our board meeting in February. And we're out.